the application process and the consideration is welcomed and something that we hope will be taken forward in the directives as well. The provision for the electronic delivery on the respondents, as well as notification to the complainant, is a welcome addition. We especially note that this reduces the burden on the complainant to follow up with the court as to whether an interim order has been served and whether they can obtain copies of the order as well as the interim warrant of arrest. So we welcome that provision. We, like many other presenters before myself, we also that results in it not being affected. So having the electronic repository provides complainants with more protection, if you could say that they're able to access it quite easily from any court. Then in the issuing of the final protection order, we welcome and support the amendments to this section, with the exception of the provision set out in subsection 2B, subsection 3, or III, where it states that if neither the complainant nor the respondent appears on the return date, the court may discharge the matter as one of the options. This provision has replaced the provision set out in the previous iteration of the bill that stated if the complainant does not appear on the return date, and the court is satisfied that the application contains an affidavit made by or on behalf of the applicant that reports that the respondent has committed or is committing an act of domestic violence, the court may issue a protection order in the prescribed form. And B, the court must make provision to locate and or contact the complainant to establish reasons for not appearing on the return date. Our submission to the committee is that this provision be reinserted into this current bill, rather than providing magistrates with the option to purely discharge the matter. Then in section 7, what we would like to draw the committee's attention to is that the provision as amended from the principal legislation that allows for a magistrate to make the decision for a respondent to not be allowed to enter the residence of a shared residence of the complainant. What we propose is that this provision be strengthened so as to not be superseded by the Protection of Illegal Eviction from and Unlawful Occupation of Land Act, or the PI Act, or any other legislation that governs evictions. We therefore propose that the following provision be included, or language similar to this, that states a protection order may prohibit, suspend, or restrict the exercise of the respondent's rights to occupy the residence for the purposes of determining who has the right to remain living within a residence and who is obliged to vacate a residence. A protection order excluding a respondent from all or part of a residence shall take precedence over the information contained in the lease, the property deeds, or any other written agreements in respect of who has the right to inhabit the property. The terms of the protection order shall also take precedence over the provisions contained within the PI legislation or any other legislation governing evictions. Finally, we support the extension of directives to the Departments of Health, Social Development, Basic and Higher Education, and Training and Communications, in addition to the Department of Justice and Constitutional Development and South African Police Service. We know that for the longest time in the current act, duty fell almost exclusively on the Department of Justice and police. And we feel that this addition brings the amendment bill in line with the call for a multi-sectoral response to gender-based violence as outlined in the draft National Strategic Plan to Combat Gender-Based Violence and Femicide. But what we do propose is that a time frame of 6 months or a time frame agreed to by the committee from the date of promulgation of the Amendment Act be provided to the Director Generals from the respective departments to finalize the directives, so that we don't sit with the case of multiple months after promulgation or years after promulgation, that we do not have clear directives in place for the implementation of this law. With that, I'd like to thank the committee, and Chair, I welcome any questions.
The problem is with me. Sorry. Thank you very much. Thank you very much, Mosiak. I have noted the following members: Honorable Mufokeng and Honorable Nevot Trachans. We will start with Honorable Mufokeng.
Thank you, Chairperson, and thanks for the presentation. I just want to check on two things. I'm really happy because I saw that you're doing training and healing, the healing center. But in terms of training, I want to check that were you training people to also understand domestic violence as an act? And I would want to ask if you had complainants, because most of the time you find abuse comes with fighting for resources and all that. Were you advising people to also can actually go and open up a case for economic abuse? Because we found that most people don't actually look at that in the domestic violence. And we just want to know from your side, have you ever helped a person in that regard? And then on the issue of the orders, the protection orders, will you support the centralized orders? Because I've seen that you are really supporting on the electronic and on the online, which is a good thing. But there are those views of saying that it also goes to an extent of saying centralized orders can be something that we should look at, because it's submissions and we should be listening to everybody. And lastly, it said it will be the issue of, can you share with us if you had any challenges with people that actually withdraw their cases, and what does it do? Because we are aware that most of the women that actually has done that, most of
Honorable Mufokeng, unmute yourself.
Oh, I'm done, Chairperson.
Okay, thank you very much. Honorable Nevot Trachans.
Can everybody see me? And am I spotlighted?
Yes.
Thank you to Mosaic for your presentation. I have two questions. And because you've worked in the field for many years, I would like to ask something about something that has happened recently. When I saw the newspaper today, it says there's an increase of online gender-based violence. So that is on the increase. So what would your view be? Is there something that needs to be added in the bill to strengthen provisions against online domestic violence or gender-based violence? And then again in the newspaper today, a police member of SAPS, was charged for gender-based violence. And now when the victim, the victim has to come first, but then the police is also involved in the criminal case. So knowing that kind of system is knowing that system, that the victim has a system against her because the perpetrator himself is in the police and has the backing of the police. So, how would a victim get further assistance in the process, taking into consideration the challenges or obstacles put up against him or her in that situation. Thank you.
Thank you very much. Over to you, ma'am, Mosiak.
Thank you so much, and thank you for those questions. In terms of economic abuse, we, as Mosaic, we provide training and education at a very local, community-based level on all forms of violence. We're also based in the magistrate courts themselves. So anybody, an applicant that appears at the court wanting to apply for a protection order, we actually assist them to do that. And that is where a lot of our education also comes in. And with that, actually raising awareness about what economic abuse is, because I think there is very little understanding of what economic abuse is. So we do it on two levels. The one is in our community awareness, raising workshops and education groups with survivors and community members, but also with community leaders, because I think it's important that we not only rely on Mosaic to provide this education, but really create a strong platform from where community members can get sound information. So, but economic abuse is one that is not often brought to the fore unless you are really talking through to a complainant what the different forms of abuse are. So I think there's a lot more work that can be done around educating around the nature of economic abuse, and also what processes are available to survivors who are experiencing economic abuse. In terms of protection orders and a centralized process, I think that anybody who goes to a magistrate court on a Monday morning and sees the queues of people waiting outside the domestic violence clerk's office will support a centralized system for protection order applications. It's something that we see on, we have the saying in the organization is, you don't plan anything for a Monday. A court support worker cannot be out of the court on a Monday, because that is the day that a lot of protection order applications come in. But also we see that the highest levels of violence are on weekends. Now we can talk about the social drivers and contributors to those high levels, but if we're talking legislation, we need to think of, well, what does that person need right then and there? So if we have people within various communities that understand the centralized order process and can do that application there, and there's a magistrate who's able to consider that application immediately, we will definitely increase the safety of complainants. Then challenges where people withdraw. I think this is quite a contentious issue, because from a procedural point of view, we don't necessarily want people to withdraw cases. But if we look at the lived experience of complainants, often they are intimidated to the point of, you need to withdraw. And it's not always by the respondents. It can be by family, it can be out of the view for their children, it can be from a range of sources. So in terms of what we propose for people that withdraw, in one way, we want to propose that the court does everything it can to make sure that such an application to withdraw is not made under duress, but at the same time understanding that the courts are seeing multiple cases and multiple applications to withdraw. So I think that's something that the committee needs to look at and maybe speak to, or maybe request submission from magistrates and prosecutors on this. Sort of what their ideas would be. But I think there needs to be a protective measure in the applications to withdraw, or considering applications. And then an increase in online gender-based violence, we're definitely seeing that, especially around issues of harassment, issues of sexual harassment, issues of domestic violence. Often what you find is when a protection order has been issued and it stipulates you will not have access to the residence, you will not, provide verbal abuse or physical abuse, it often then moves digitally. So it moves into that digital realm. And social social media, as much as we love it, it's really created a very problematic platform for victims and survivors of domestic and gender-based violence. So in terms of the bill itself, I think the bill has gone a long way to really start thinking about what does this electronic form of violence look like. And I think it's quite sound in that way. I think where the challenge comes in is how to protect or how to present that information to the court. So how does it get attached to a protection order application? If an applicant comes to the court procedurally, they've got their phone, they've got the evidence, but how does it make it into the application? And I think having a centralized online system is great. You screenshot it, you upload it, it's there. So I hope that answers your question. Then the police member charged for gender-based violence, it's one of the honorable members in previous sessions actually spoke about complainants going to police to seek assistance, and yet the person themselves who are assisting them could be perpetrating violence at home. And this has been a challenge for a very, very long time. And I think we need to start looking at the police service in and of itself. We need to consider that members within the police service come from the same society, the same communities from which they serve. And we need to start looking at how do we change the service? And I don't think legislation can do that. I think we need to start looking at how do civil society, how do police, how does Parliament sort of all work together to try and say we need to start humanitizing. I don't think that's a word, but how do we start humanizing the police service? How do we start really unpacking, firstly, who deals with domestic violence matters? Is it someone who's specifically trained for that? Is it someone who's sensitized to the needs of a victim of violence? But then also taking very strong and harsh disciplinary action against police who obstruct justice for victims of domestic violence. So that would be my suggestion and my submission. I know it's not a very tight, compact one, but I hope that helps.
Thank you very much, ma'am. Thank you very much for your presentation. But we should not single out only police officers.
Yeah.
You might find a magistrate or a prosecutor who in his or her house is also a perpetrator. I think it's a societal problem that we would need to attack. Thank you very much. And I was impressed that you also gave a wording that you proposed in one of the sections as to how it should be crafted. That is what we appreciate, that we don't possess all the wisdom. So we would like society to assist in whatever form so that we are able to have the best legislation that is not only good on paper, but a legislation that will be implementable, that will be able to change society. This issue of domestic violence is a very emotive thing, and it can affect all of us. Sometimes the tendency is to think that it affects only the illiterate women, the poor women, but even those that are highly literate, professional, are also highly affected, some of them, by this domestic violence and femicide. Thank you very much. I think we have come to the end of the meeting for today. Tomorrow we have a very packed program. Also, we will have to include the Women Legal Center and Professor Skelton. So we must be prepared at least to work until 4 o'clock. But I don't think that we will work beyond that time, but we will try that by 4 we are done. And one of the things that I would want to emphasize is that as Parliament, as a committee, we give equal weight to written submissions and to oral submissions. We are bound to give consideration to all of them and gave equal weight to both written and oral submissions. Thank you very much, members. Tomorrow we'll start at 9 until we are done. Thank you very much. The meeting is adjourned.